We're live.
Yeah, next.
Good afternoon. It's 4:42 on the 15th of March. This is the House Judiciary Committee, and we have a voting session where we're going to continue down through voting list number 8, or I can't remember whether we started 8 or 7 yesterday, but whatever, it's a voting list. We're going to go in numerical order. We stopped yesterday at House Bill 559, but we're actually going to start at House Bill 34. There are a couple of these bills prior to 559 that went through subcommittee. So we're going to start there and work our way down. Literally all of these bills have amendments. All of them, except one, have amendments. So they all have, well, might take a little while, but we'll find out. So let's start with House Bill 34. This is Delegate Crosby's bill. The amendment on this bill is amendment, since just the one, 883423. Let's do this. Let's council, and this is Claire. Claire, can you tell us what the amendment does? This went through the subcommittee, right? So actually either Claire or the vice chair, could we learn what the amendment does, and then hello to your dog, and then we'll then go to the bill as amended.
The amendment adds requirements that the act be done with prurient intent and that the minor victim be more than 4 years younger than the defendant.
All right, and this came out of the subcommittee, correct, Mr. Vice Chair?
Yep.
Move the
Okay.
amendment.
So motion for the amendment. Is there a
Second.
All right, moving and seconded.
Move
Is there
favorable as
discussion?
amended.
Well, hang on. So do we have any discussion on the amendment? And we do. And here comes Delegate McComas. Delegate McComas is on mute though, so we can't hear her comments until she unmutes herself.
Just my question is, how are we going to establish with prurient intent? I don't know how we're going to establish that. I don't think we're going to get a conviction on anybody personally.
That language is in other sections of code, so it's not a new term without history. And we had a pretty lengthy discussion about prurient versus lascivious and things of that nature.
Well, my question is though, where is it in other sections? I mean, it seems to me because the victim is more than 4 years younger than the person. So I mean, I don't understand why you need
to be clear, the intent of that. So that amendment also came in, I believe, by request of MCASA, some of that language, but the prurient intent was meant to exclude someone peeing in public, things and a technical indecent exposure that wasn't of the variety that's intended to be captured by this crime, which we're enhancing the penalty to make it 5 years. And so we wanted to not just have an incidental indecent exposure. We want it to be a serious offense, and that seriousness was as so, this is about people masturbating in public or exposing themselves with a sexual intent in front of a child. And again, to kick the sort of public urination out, we put prurient intent in.
Well, let me just ask a quick question. Did the prosecutors have a chance to comment about this, that they thought it was okay and that they could be able to prosecute?
Yeah, we didn't have any opposition. And I think this was a unanimously adopted amendment.
Right.
Yep.
Okay, thank you.
Any further questions on the amendment? Seeing none, all in favor of the amendment, please raise your hands. Howell, Arakan, Shoemaker, Cox, Grammer, Jones, Cardin, Shetty, DeComas, Lopez, Moon, Tolles, Bartlett, Cham, Fisher, Davis, Crutchfield, Munoz, Williams, and Anderson. Don't see anybody opposed, I don't think, but just in case anybody opposed. Seeing none, all right. The amendment's adopted. We're on the bill as amended. Is there a
Move
motion?
favorable.
Motion for a
Second.
favorable in a second. All right, so Let me check. One other thing here. Okay. Mr. Vice Chair, my understanding is that Delegate Pippy had a couple indecent exposure bills that your subcommittee was dealing with. Are you still working on those bills?
No, we move fast.
Okay.
So our bills are out. There was a request so Delegate Pippy had two bills. One of them was also seeking to amend the same section of code as this bill. It's the one we didn't move. So we didn't move Pippy's bill on this, and he has requested to move his name on to the Crosby bill as a sponsor. I told him that was up to you.
All right, so we in the past, we haven't been doing sponsors through the pandemic because it would result in a million of them. However, what I'll say, and the small explosions you hear in the distance are my council's head exploding a little bit. I'm willing to take sponsor add-ons if the bill is already being amended, and that is the case here. So it is already being amended. If you wish to have your name added to the legislation, we're going to add Delegate Pippy's name to the legislation. Please raise your hand now, and I am going to do not lower your hand until I read your name, and then that way we can, yes, that way Claire can hear them and we can go from there. If you'd like to be added, here you go. Cox, Shoemaker, Arakan, McComas, Grammer, Cham, Fisher. I think I said McComas and Cox. So that they'd like to add on. So they are on the bill now. We're adding that as an oral amendment. Any objection to that? Not seeing any objection to that. That amendment is adopted. So we're now on House Bill 34, favorable with amendment. There's a motion for a favorable. We'll just presume that amendment. Is there a second on that motion for a favorable? All right, great. Any further discussion? Seeing none. Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
I'm sorry, yes.
Anderson, Kurt,
He has
I-
a thumbs up.
thumbs up. All right. Arakan,
Yes.
Bartlett,
Yes.
Carden. Now Carden.
Yes, I'm sorry, yes.
Conaway, Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes,
Munoz,
Yes.
Yes.
Shetty, yes, Cham,
Yes.
Tolles,
Yes.
Williams,
Yes.
21. Okay. Let's go to this one. House Bill 67. Jazz Lewis's bill. There is an amendment, and this is also Claire's. Delegate Lewis has been in contact with me and been in contact generally with regard to the bill. My understanding is that he is fine with the new language that basically would replace the bill with, to the extent possible, the Commissioner of Correction may not prohibit an inmate placed in restrictive housing from having access to a reentry specialist or case manager within 100 days prior to the direct release of the inmate from a correctional facility to the community. That is the amendment for House Bill 67. Could I get a motion on the amendment, and then we'll discuss.
Move the amendment.
Is there a second?
Second.
We're on the amendment. Does anybody have questions? Delegate Shoemaker.
So the original premise behind the bill providing for a cause of action and that sort of thing, that's stricken now. for
That
this
all
amendment?
goes away. That goes away.
Okay, thank you.
My understanding is that Delegate Jazz Lewis has also been in contact with the Department of Public Safety and Correctional Services regarding the language used in the bill.
Okay.
All right. Are there further questions on the amendment? All right, all in favor of the amendment, please raise your hands. Howell, Shoemaker, Cox, Grammer, Jones, Carden, Shetty, McComas, Lopez, Moon, Tolles, Bartlett, Cham, Davis, Crutchfield, Munoz, Williams, Anderson. Anybody else? And Fisher and McComas. Anybody opposed? Seeing none, the amendment's adopted. We're now on the bill. Is there a motion?
Move favorable.
Motion for a favorable. Is there a second?
Second.
All right. Any further discussion on the bill as amended? Seeing none. The vice chair.
Yes.
Shoemaker,
Yes.
Anderson. Hurt. I
Yes.
see thumbs up. There we go. Erican,
No.
okay. Bartlett,
Yes.
Carden,
Yes.
Conaway, Cox,
No.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
yes,
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Poles,
Yes.
Williams.
Yes.
All right, that's 18. That's going to the floor. Delegate Carden, do we actually have the amendments this time, Delegate Carden?
That's
And
fine.
I I want to make sure that the committee received the new amendment that was drafted. If not, I'll have to hold this till the end of the voting session. Andrew's making sure that Holly has it.
We do not, or at least it's not in this packet. And if it's, and that's okay. We're gonna.
It's coming. Holly, it should be in your
So
email right now.
I Delegate Carden, I just received it from Andrew, so I just forwarded along to Dylan for you.
Okay, so I can explain it, Mr. Chair, or we can just wait and Dylan can, or.
Let's just do it the right way. We're going to have another voting session tomorrow. We will do it the right way. It's not going to be the end of the world. So and I don't think it's a complicated amendment. I think we all understand what it does. I would
Right.
just rather we have it.
Okay,
They would rather we have it as opposed to not. So we'll hold on to 176. And we're going now to 187. This is Delegate Terras's bill. We have been here before. And it deals with the fees in the administration of estates. There is an amendment 953024. I think Delegate Williams, you were talking to people, I believe, about this. Can you, I can ask you to tell us what the amendment does, or I can ask council to do that. I'm fine either way. Have council do it. I'm fine having Holly. Holly,
that's
can you tell us what Delegate Terras's amendment does, please?
Sure. So the bill revises the probate fee schedules so I'll just start at the beginning what the bill actually does. The House Bill 187 alters the existing statutory fee schedule that may be assessed by the Register of Wills. This includes eliminating probate fees for the smaller estates and altering the probate fees for the larger estates. The amendment strikes the added language for the fees related to the issuance of a show cause order, and that's under subsection Q. And the amendments revise the probate fee schedules for Roman number 7, 8, and 9, which are the larger estates. The 5 million, between 5 million and 7 million, and 7 million and 10 million, and over 10 million for those larger fees.
Okay. Are there questions that members of the committee have related to the amendment?
Yes.
Go ahead, Delegate. There are lots of them. We'll start with Delegate Shoemaker, then Delegate Fisher.
Thank you, Mr. Chairman. So what's the net effect of the changes at the higher end of the scale, as it were? How much are they going up, in other words?
Sorry, Delegate, I'm just looking for my amendment.
That's okay.
Sorry. So for the 5 million to 7.5 million, the fee is going to be 7,500. For the 7.5 million to 10 million, it's going to be 10,000. And then let me go back into the bill. I can tell you what it was before.
And what are they now, by the way?
Yep. So, so this is on page 3 of the bill, if you have it in front of you. And so these are new Roman numerals. So the Roman numeral 7 that's there is the last one, and it's 5 million to, it has no at least amount. So it's just any estate over 5 million.
Right.
So then the new amendment, that would be 10,000. So the amendment breaks that down into 3 new categories. You've got the 5 million to 7.5, the 7.5 to 10, and then over 10, instead of just capping it at 5 million. If that makes sense. If you look at page 3, if you can pull up the bill, you could see the fee schedule.
Okay.
And then the new fees that are associated with that on the amendment. So, but for the 5 to 7.5 is now 7,500, whereas that would have fallen under the 10,000 category, the bill as drafted before the amendment. And then the 7.5 to 10 is the 10,000. And then you have the over 10.
And at the bottom end, as I'm understanding it, it eliminates the probate fees for anything less than $50,000. It raises that floor from $10,000 to $50,000, correct?
Yep. And then that fee is now 0. And then it progresses up for example, 100,000 is now $100 versus it was scattered between 100 and 200. So
it actually lowers it for every estate. And I'm sorry, I'm intervening on Delegate Shoemaker's question.
no,
No,
sure.
that's quite all right.
So right now, if it's under 10 grand, the fee is $50. If it's between 10 and 20, it's 100. If it's between 20,000 and 50,000, it's 150. This would eliminate the $50, $100, and $150 fees and make them 0. So everything under the $50,000 estate zeroed out. Then the next level would go from 50 to 100,000. Right now, between 50 and 75,000, it's $200, and 75 and $100,000, it's $300. It now sets 2 new levels, one that's between 50 and 100, that's $100, so half as much, or even as a third as much. And then from 100,000 to $500,000, it lowers it from either $400 if it were between $100,000 and $250,000, or $500 if it were $250,000 to $500,000. So if your estate is under $500,000, it lowers the fee under the bill. If your estate is over $500,000, then it raises it in some amount, and as has been described by counsel. So at least that's the way that I see it there. I'm going to go on here, and Delegate Juanita Fisher, then Delegate Tolles.
Thank you, Mr. Chair, and thank you so much for Tahali and Delegate Williams for your work on this bill. I think the one concern that I wanted to point out is the $500,000 value to $1 million. At least I can say in my little corner of the world in District 47. I mean, the house next door to me just sold for 450 with like nothing. I think the property value and what we're talking about for very much middle class Black and brown families, they're going to be between $500 to $1 million, at least on the value of their home, let alone if they have a few jewelry pieces and something like that. And they're not extremely wealthy. It's, you know, the house has appreciated in value being in the DMV region. And that's what concerns me. I think it's great effort and amazing, definitely for the under $500,000. But what really concerns me is the 500,000 to, I would say, $1 million to $1.5 million. I mean, a new townhouse in Hyattsville right now is 1.2. And so I just,
Mr.
it's an
Chair,
issue.
just to remind.
Hold on. Delegate Fisher has a question, so hang on. And there are other people wanting to ask questions. So let me.
So I
Delegate
guess
Fisher.
with I just wanted to give that context about like where housing is in my community, which is not the richest, you know, in the land around here. Is like, how does it adjust over time, or is there a way that it will adjust in future to help that kind of middle section I'm talking about? Or when you do the fee structure, like that's it forever?
I mean, I do think, and I can, and others, if you want to, I know Delegate Williams was involved with this a little bit. If other people want to get in, that's fine too. I mean, obviously we're here looking to change the numbers now, and that this is part of the sort of ongoing process where we evaluate these and reevaluate the fees that are out there. I would say that for the people who are between $500,000 and $750,000, the fee right now is $750. It's not, I mean, an extra $250 is not insignificant, but it does raise their fee. If you have an estate between 500 and 750, it does leave the fee, as I read it, the same. I believe from 750 to a million, it's already 1,000. It would remain 1,000. So it's worth mentioning that. But there's no question that then the bill raises the fee for people between $1 million and 2.5 from $1,500 to $2,000 on their probate fee. So that's what the bill says, I guess. Now, Delegate Williams, did you want to say something as well?
Yeah, I was just going to say, from my understanding, talking to the bill sponsor, the increments are basically 20%. Increments is what kind of the step up amount differences are from the previous stepped up amount. You know, just looking at the fiscal note from what was originally in the bill, and, you know, Chair was correct, the 750 goes up to 1,000 for the 500 to 750, then it stays 1,000, but then it is a little lower in some instances, even with some of the higher estate amounts. And one of the things that Delegate Taraz, I think, was trying to accomplish with the amendment that she put in was, so it, you know, trying to minimize the balloon all the way up to 10,000 on some of the larger estates and make that a little bit more gradual. And so that was one of the purposes of the amendments. The explanation, like I said, was given is it's 0.20% difference of the value from the beginning of the ranges going up. And it was something that the registers have been working on for a number of years. They said the fees hadn't been changed in over the last 30 years. So this was just an effort to try to make it a little bit more equitable, especially for a lot of the smaller estates. And so, but I definitely understand your concerns, Delegate Fisher. I mean, I live in a district where you're right. I mean, a house in my district can easily sell for roughly $800,000 easily. And so with kind of given that hypothetical under this bill, if I had an estate of $800,000, then I would have to pay $1,000, which is actually the current amount currently under current law. So she tried to make an effort to try to keep it as low as possible, especially as we're going up, thinking about some of the larger jurisdictions like Prince George's County and Montgomery County.
All right, we're going to go to Delegate Tolles, then Erican, then Grammer, then Cardin. Delegate Tolles.
Thank you, Mr. Chair. Some of my questions have been answered, have been asked rather and answered. I just want to, first I want to thank Delegate Williams, who, you know, worked with the bill sponsor on some of these numbers. I know we talked about one of the concerns I have. I can tell you that there are houses in Prince George's County now that are over, $2 million, believe it or not, that this is a big $5,000 jump. So I did want to mention that. It goes from 2,500 to 5,000, and then even, well, I would just keep it there. I don't really not sure where we are with the 5 million, but certainly some of the discussion that Delegate Fisher mentioned, as well as this next tier, I am concerned with, those jump in fees. So I just wanted to note that for the record. Some of my questions were answered in terms of understanding where it was before versus where it is now. So thank you, Mr. Chair.
Delegate Erican.
Thanks, Mr. Chair. Just to echo what some of my other colleagues have said, concerns about the value of real estate, as we see inflation go up, house values are going to go up. And I'm just not comfortable. I feel like it's maybe a little tone deaf right now in such an economic unknown to be allowing the state to take more money from people when their relatives pass away, when we have no idea what the economy is going to look like in the next 12 months, certainly down the road. So I just don't see, I know we had this bill last year and it looks like it didn't move. I'm just not a fan of fees or taxes. So I'm not a fan of raising that when we have such economic uncertainty.
Delegate Grammer.
Thank you, Mr. Chair. So thinking back to last session, this bill actually failed in subcommittee. And it did so because a lot of the same arguments we're hearing today were echoed in the subcommittee. And I think it was general concern that these kind of rates are forward-looking, and we're saying in the future, this is what's going to apply. And I believe it failed because I understand the need to eliminate the fees from the lower end, but right now, even in my district, I have row homes pushing $300,000. By the time my kid buys a house, they're not going to be able to get a row home for less than $450,000. And this amendment, it doesn't help very much. We're pretty radically scaling things up here. So I just wanted to get a feeling for why, understanding the prices even for row homes are skyrocketing over the last 20 or 30 years. Why are we so stuck on scaling up the higher end of the fees so significantly here? Because the amendment doesn't, I had suggested if we want to just knock off the lower end of the fees, just knock off the lower end of the fees. Why are we so dead set on putting in place something that's going to be a pretty significant cost to anyone who accumulates even just a low level of wealth?
Delegate Rammer, I think it actually lowers the fees in the middle of the price point. So giving your hypothetical of $300,000, under current law, that person would have to pay $500. And under this bill, they would have to pay $200. So it actually lowers the fee under that price point that you mentioned, and even Delegate Tolles with the 2 million. Right now it's $2,500, and this would lower that to $2,000. So
sorry, go ahead.
No, go ahead.
So the point where people really start to get hit is the over $500,000 area. And looking forward, the prices going forward are not at all going to be the prices what we have right now, which are already extremely high. So looking at these middle ranges, that's where it's really going to start to hit people. And I think it's what we define as lower income right now is going to be everybody very soon. So are we that averse to just knocking off the lower scale and raising everything? Are we dead set on that? I just don't think this is the time to do this right now. And I hear the same concerns that we heard last year. The bill failed in subcommittee.
Delegate
Yeah,
Cardin. All right, go ahead, Delegate Williams. and we'll
No,
go
that's
to
okay. That's fine. Delegate Cardin is.
Delegate Cardin.
All right, thank you, Mr. Chair. So we spent a tremendous amount of time on this bill last year in subcommittee, and we knew that the concerns that you raised, Delegate Grammer, the same concerns. Let me give you a different perspective. I think that we all need to step back and realize, number one, this is about treating like individuals fairly and equally, and not essentially treating people with a $50,000 estate the same way as you would treat somebody with $1 million or $2 or $5 million estate. And this is only the most important fact that we have neglected to talk about is this is only for properties or for estates that go to probate. The vast majority of these properties, that are particularly ones worth $500,000 or more, people are planning appropriately. Either they're in joint, the real estate's in joint tenants, or the deed is in multiple names so that they can make sure that the property transfers without going to probate, or the estate has some sort of estate planning to make sure that there's a beneficiary or a will that designates who the property is going to go to. None of those states are going to be implicated in this legislation at all, none of them. So the vast majority of them, and I understand Delegate Fisher and I already had a conversation about this, and there are people that don't have planning that might have a $500,000 house. That is possible, sure. But the fact is that the probate work has to be done by by whether it's the Register of Wills or the orphans courts or the circuit courts. They've got to spend a lot of time, and a disequal amount of time on those larger estates. And that's why we should have to, those are the states that should have to pay the additional money. And yes, anybody who has an estate of $500,000 or less should pay less, or should pay a smaller amount. And because those are the ones that are likely to have to go to probate. So the vast majority of the ones that go to probate are not paying, or they're paying less amount. And the vast majority of the ones that are greater are not going to probate. And those few that didn't plan, that have these immense estates that are going to cause all this work to be done, are the ones that are paying the big bucks. I think it's a very smart public policy. There are going to be a few people who are going to wind up having to pay these big numbers because they have a $10 million estate that went to probate for whatever reason. But the vast majority of them, this is about making sure that these companies, offices have the ability to handle all those small $50,000 estates that go to probate but aren't paying a penny. And so I think it's a good policy idea. And look, Delegate Terrazza wanted to push the bill. I knew that we probably didn't have the votes back then, but I think that she has made the case. And by the way, as Holly already indicated, and the chair did a great job of talking about this, these are not the same numbers as last year. Terrazza did a really good job of making sure that those smaller ones are the ones that are not paying, or they're paying a much, much less. And the bigger ones are the ones that are taking the big chunk of this because they didn't plan accordingly. So I think it's a good policy, and I'm going to support the bill. Sorry to go on for.
All right, Delegate Rachel Jones, and then the Vice Chair.
Thank you, Mr. Chair. I'll just say that I know last year I had a lot of major concerns with the bill, particularly in subcommittee, that I raised with the bill sponsor. And over the interim, I felt like they were very considerate of some of the points I had raised last year about the caps and the fees for certain estate amounts. And similarly to what Delegate Fisher mentioned, I was concerned. There are folks who are not able to pass down generational wealth because, some of these fees would have just eliminated some families' abilities to be able to keep property within their family. However, I will also agree with Delegate Cardin that I feel like the sponsor worked with me a lot during the interim to answer some of my questions and to make some adjustments to some of these fees. And so I will be supporting the bill because I feel like they've worked very hard to try to make some changes and adjustments that would make it more feasible for families who are land rich but cash poor and might have difficulty paying some of those higher fees. And I do feel like the bill sponsor and the advocates did a good job trying to make those adjustments. And I personally feel comfortable with the changes that have been made.
Okay. The vice chair, please.
Thank you, Mr. Chair. I hate to belabor this bill because I think we're making more of it than need be. I would just point out a few things. We're talking about people inheriting money, essentially, and money coming out of the estate. So as was just noted, this is about intergenerational wealth transfer and making the system more progressive. I will point out that in a series of actions that I disagreed with, the Assembly got rid of the millionaire's tax bracket in a sunset years ago. There was an increase in the estate tax in Maryland so that up to $5 million your estate and your heirs are exempted from paying those taxes. Again, I disagreed with all of this. And so here we have a very modest increase on the base property here. And so the concern here is raised at the $500 to $1 million level. The increase is $250. And after that, the increases are a few $1,000 on people inheriting $1 million to $2.5 million, $5 million estates. I don't really care about that extra, $1,000 there if on the balance what it's doing is making it revenue neutral, meaning we hold harmless the taxpayers so that we can exempt the $50,000 low-level estates and to help the poor people. That's the deal here. We are essentially holding harmless the taxpayers so that we can help those without the means to keep onto the family property. And if the way to do that is by increasing the fees on people inheriting multi-million-dollar estates, I think that's totally reasonable. The line had to be drawn somewhere, and I guess they cut it in this bill at $500 to $1 million. But again, it's a $250 increase for very good purposes. So I hope you all support the bill.
All right. We are on the amendment. So let's do this. I mean, ultimately, I think the questions surround what the amendment would do. So I'm going to go ahead and make everybody a little bit crazy, but I'm going to go through and describe what the probate fees would be under the amendment. Again, this is the amendment 953024. So I'm going to do, first of all, I will not read what they currently are because you can read that in the law yourself. What they would be under the amendment, however, is if the value of the probate estate is under $50,000, there would be no fee. If it were between $10,000 and $100,000, it would be $100. Between $100,000 and $500,000, it would be $200. Between the $500,000 and $1 million, it would be $1,000. Between $1 million and $2.5 million, it would be $2,000. Mercy. Between 2.5 million and 5 million, it would be $5,000. And between 5 million and 7.5 million, it would be $7,500. Then between 7.5 million and 10 million, it would be $10,000. And for any above $10 million, it would be $10,000 plus 0.2% of the excess over the $10 million. So roughly for every million over, it would be, I'm doing math. For every million over that, 1% would be 10,000. And so then again, it'd be another $200 for every million over 10 million. It would be 200 on top of the $10,000 that was there. I believe I've gotten that right. I don't see anybody jumping up and down saying I've gotten it wrong. That's what the amendment would do. Is there a motion on the amendment?
Move the amendment.
Motion for the amendment. Is there a second? There's a second. All right. We're on the amendment. And since it feels like there's some back and forth on the amendment, I'm going to be kind of slower this time. I'm going to ask you to raise your hand and leave it up until I call your name. And then after I call your name, I'm going to ask you to take your hand or lower your hand. And then that way I can keep track. Okay. So all those in favor of amendment 953024, please raise your hands. I see Howell, Shetty, Carden, Jones, Lopez, Moon, Bartlett, Williams, Crutchfield, Davis, Fisher, Anderson, Shoemaker, Tolles. All those opposed to the amendment, please raise your hands. Arakan, Cham, Grammer, Cox, Munoz. Miss anybody? Don't think I did. All right, the amendment is adopted. We're now on the bill as amended. Is there a motion on the bill as amended?
Move favorable.
Motion for a
Second.
favorable in a second. All right. Any further discussion? Seeing none. The vice chair,
Yes.
Shoemaker,
No.
Anderson,
Yes.
Arakan,
No.
Bartlett,
Yes.
Carden,
Yes.
Conaway. It's excused. Cox,
No.
Crutchfield,
Yes.
Davis,
Yes.
Juanika Fisher.
Yes, but can I explain my vote?
Yes.
I'm voting yes, because I do support all the work that's been done, and I do support as Vice Chair Davis, not Vice Chair Davis, Vice Chair Moon. Good ring though. Vice Chair Moon talked about in helping indigent folks, even though I can't imagine what's 50 grand in my community. I don't know what is being probated out, but I do hope that the committee does consider what's going to happen as time goes on and would be open to adjusting fees for those that are going to hit that 500 to $1 million to $1.2 million, because that literally is my community. And I will tell you as well, I want to put on the record, my undocumented community are buying homes in straight cash and do not have wills done and probates happening. And I'm just, I just want the committee to be aware. Do not think that's not happening. They totally are. And I just think that should also be considered. But I will vote yes for the work that was done.
Delegate Grammer. Delegate Grammer.
No.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
No.
Munoz,
No.
Shetty,
Yes.
Cham. Sorry.
No.
Thank you. Tolles,
Yes, I can't do the yes the way Carr did it yesterday, but yes, similar to his yes of yesterday. Yes.
Williams,
Yes.
$13. It's passed. All right, and so let's move on. Going now to House Bill 211. There is an amendment. It's 803-329. And either, I think, Holly or the vice chair, either one of you, would you like to tell us what the amendment does? This went through the criminal law subcommittee.
Sure, I can.
Go
get
ahead,
it.
Delegate Moon.
Sure. The amendment strikes the bill. It's one of those. the bill originally attempted to felonize a straw purchase of a firearm to a prohibited person. And the bill, as the subcommittee moved it, instead, it adds that offense to a list of crimes whereby law enforcement can do a warrantless arrest, an arrest without a warrant, but with probable cause. And that list of offenses is in 2203 of the Criminal Procedure Article. It includes a range of things like manslaughter by vehicle, theft under 1,000, prostitution, and some firearm offenses like concealed carry offenses and indecent exposure. You can see the list here in the link. Again, it's 2203 of Criminal Procedure.
All right, we'll take, oops, yeah, well, I'm already here. We'll take questions on the amendments, but let's move it first and then we can take a vote on it.
Move the amendment.
Motion on the amendment, is there a second?
Second.
All right, that's fine. We'll take now questions. Could I hear now from Delegate Grammer's forehead?
Thank you, Mr. Chair. So if I remember properly, the purpose of the bill was that they weren't able to prosecute the crime technically, like there was a technical issue with the offense. Can you help us understand more clearly how the amendment solves their problem?
I don't think that the problem, I think that the issue was that I think that her argument was by making it a felony, it would be able to be charged in circuit court and that there may be more attention brought to it. And I'm sorry to step on the vice chair a little bit here, but I think what the amendment is doing is kind of moving in a little different direction and saying that if a police officer, I mean, right now it's a misdemeanor, and if a police officer isn't actually present to see the straw purchase, which it would be very difficult to, actually see the straw purchase if you're an officer, then it would be difficult for them to be able to investigate it. So to that end, it's seeking to get at this problem slightly in a little bit of a different direction.
Okay. Okay. Thank you.
All right. Delegate Erican.
Just to explain a little further what the amendments do in practice. So if the officer shows up at the scene of a crime and the perpetrator is arrested and he says, I got this gun through a straw purchase, the officer could then go and arrest the person named by the alleged perpetrator without having to have a delay where he has to then go or she has to then go to the judge and take the evidence and get the warrant, because first they'd have to interview the person and all this just allows them to quickly say, okay, they've named a person who straw purchased this firearm for them. We're going to go pick that person up before they get a heads up that, the person they just sold a gun to just used it in a crime and got nipped. So I think they're just trying to cut that time frame down. So it's just a little bit easier for them to get the person who's actually committing the straw purchases, because that, I guess, has been, another difficult piece of the straw purchase issue. Not just that there's not resources going there, which is still a problem that, I still think we should address at some point, but also when they do get the information, there's this lag in their abilities to go pick up the person who's been named. So.
Okay. Go to Delegate Lopez, please.
Thank you, Mr. Chair. So it's my understanding that there's 3 actions that have to take place in order for someone to have participated in a straw purchase, right? You have to fill out an application, you have to take possession of the firearm, and then you have to give it to someone else, right? So there's like a chain of custody element there. Do all of under this bill and now with the amendment, is it still all 3 of those things that create that offense?
Nothing changes in the offense as I read it. And if the vice chair disagrees, he agrees with nothing changes with the offense. It just gives the police officer the ability to arrest without actually observing all 3 of those things happening as I read it.
So previously the officer had to see those 3 things and now they just.
Yeah, right. I mean, they would have had to, not quite have to be done in their presence. And counsel, if I'm stating that incorrectly, you can let me know.
No, that's as I read it too, Chair.
All right.
Thank you.
Okay. All right. So we're on the amendment here for House Bill 211. It's been moved and seconded. Don't see any further questions. Without that, anyone in favor of the amendment, please raise your hands. In favor of the amendment, raise your hands. Eric and McComas Moon, Lopez Jones, Carden Shetty, Howell, Bartlett Cham, Williams Munoz, Crutchfield, Shoemaker, Grammer, Fisher, and Davis, and Tolles. Anyone opposed to the amendment? Seeing none. All right.
Move favorable.
Motion for favorable. Is there a second?
Second.
All right, motion and second. Any further discussion on the bill as amended? Seeing none. The vice chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway is excused, Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher.
Um,
Sorry,
I was saying a baby, yes, but yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Bowles,
Yes.
Yes.
yes, Williams,
Yes. Yes.
yes, 20. All right, we'll keep moving. Delegate Hill, this is House Bill 437. There's an amendment in the form of a reprint that was in your packet. This is 543428. Some considerable amendments here, I think. And Claire, can you, did we send this, Vice Chair, did this go through? We didn't do this through the subcommittee, did we?
We did.
Okay, let's, the Vice Chair and or Claire, if you would let us know what the amendments do, please, and then we'll move and second them and have discussion.
Sure. I'll start and maybe Clara can fill in, but the bill started as a penalty enhancement to swatting and jamming phones, and it was writing this to a couple sections of code, but with Council Claire's help, we rewrote the bill into 9501. And that's a section about false statements to law enforcement. So we just changed the underlying offense from 6 months to 3 years and made sure that it clearly included the false statement to the public safety answering point. The original bill had a number of conditions and sort of factors, but we just did this on the existing false statements offense in existing law, essentially moving it from 6 months to 3 years to capture the more serious swatting offense. And the original offense is not just to a false statement; it's a false statement that's intended to cause an investigation of someone in a deceptive manner. So you're trying to sick the police on someone with a lie to the police.
All right, Delegate Fisher with a question.
Not a question, but I didn't know if Mr. Vice Chair wanted to also highlight just the consideration in line with Delegate Jackson's bill on the racial calls as well. And so I think the amendment is good, and that was also taken into consideration.
Okay. All right. Are there any other questions? Or well, okay, so let's have a motion on the amendment. There, right? Is there a second on the amendment?
Second.
All right, moved and seconded. Here we are, all in favor of the amendments. Delegate Anderson, do you have a question or do you have?
Yeah, I got a question.
Okay, go for the question then, and then we'll.
So on the amendment, Delegate Moon, what is the new penalty for the swatting part of it?
It's up to 3 years or $500. And that was, it started as 6 months or $500, and now it's up to 3 years. And we folded in some of the language about the public safety answering point being the place where you made the call.
Okay. And is that similar to, I remember we raised I'd raised a question about pulling a false alarm. Is that the penalty is similar to pulling a false alarm?
That's higher, but I think we went a little bit slower on this. There were
Okay.
2 sections of code with penalties in here. One was 6 months, the other is existing 3 years. And so we just took the 3 years and moved everything up to that higher amount and left it as a misdemeanor. I think the bill originally came in as a felony and sought more time for all of it.
And is the term swatting actually in the bill?
No.
Okay.
That would be at the prosecutor's discretion. They would charge it and seek more time based on the facts.
Okay, because just for the record, I did talk to the Maryland Police Training and Standards Commission, and there's number one of all the jurisdiction, of all the agencies in the state of Maryland, there are very few that even have SWAT teams. And in most cases, the SWAT teams won't get called based upon the mere call from a private citizen, but they'll probably send an assessment team out of routine patrol officers who would then either agree or disagree with the need for the SWAT team. And that's from the executive director of the Maryland State Police Training Standards Commission.
Yeah, and here we just generalized it so that the penalty is as to a false call in general that is intended to sic the police on someone.
Okay. All right. Thanks a lot.
Yep.
And are there any other questions on the amendment? All right, seeing none, all in favor of the amendment, please raise your hands. Anderson, Howell, Erican, Lopez, Jones, Carden, Shetty, McComas, Moon, Bartlett, Cham, Williams, Munoz, Shoemaker, Grammer, Fisher, Davis, Crutchfield, Tolles. Yes, I think I got everybody. Anybody opposed? Seeing none. All right, the amendment's adopted. We're on the bill. Is there a motion on the bill?
Favor.
Motion for a favorable. Is there a second? All right.
Second.
Moved and seconded. Delegate Carden with a question.
Just a comment, Mr. Chair, I just want to note for all the Republicans, I believe that Delegate Moon is going to be voting to increase penalties.
Jury's not in yet.
Oh,
He hasn't voted yet.
this will be entertaining for everyone. All right. Great. Thanks. Are there any?
Kind of throw the vote.
Oh dear. Well, let's see what happens next. Are there any further questions? Delegate Anderson's hand's still up, but that's because he asked a question before. That's fine. Okay. We're gonna go for a roll call. The vice chair.
Yes.
Okay. Shoemaker,
Yes.
Anderson,
Let's get those guys. Yes.
Erican.
Yes.
I'm sorry. I'm just, okay. Need a moment. All right. Bartlett,
Yes.
Carden,
Yes.
Conaway, excused, Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Monica Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Comas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Bowles,
Yes.
Williams. 20. All right, now we're back to where we were yesterday. House Bill 559. This is Delegate Juanica Fisher's bill on probation before judgment. I have the sponsor's amendment. I do not have any other amendments. We did hold the door open, make sure if anybody wanted to offer any further amendments here in committee, didn't get anybody else. So we're on Delegate Fisher's amendment, and just Delegate Fisher, again, would you limit to the to the purpose of the amendment, please. And can you tell us what the amendment does?
Yes, the amendment has got two parts, Mr. Chair. Amendment number one in my amendment adds clarifying language that states that the consequences under the probation for judgment would be the same, and all laws would apply in either form you would choose. And a number two also adds clarifying language based on a facts justifying a finding of guilt, and also adding in that any sentence or agreed upon disposition under the probation before judgment language, all other consequences and purposes under state law would also qualify. So all of the repercussions would be the same, so that there was no difference. For example, like I brought up yesterday, if you would lose your firearm due to a certain crime or something like that, it would all remain the same. And that is what the amendment does. And the clarifying language was really important to our domestic violence advocates and state's attorneys.
All right. Are there questions? There's motion for the amendment. Is there a second on the amendment?
Second.
All right, thank you. So we've moved and seconded the amendment. Is there discussion on the amendment? Seeing no discussion on the amendment, all in favor of the amendment, please raise your hands. On the amendment. Moon, Lopez, Jones, Carden, Shetty, Howell, Crutchfield, Munoz, Williams, Cham, Bartlett, Tolles, Shoemaker, Fisher, Davis, Anderson. Anyone opposed to the amendment? All right, and I see Cox. Anybody opposed to the amendment? All right, the amendment's adopted. We're on the bill as amended. Is there a motion on the bill as amended?
Move favorable.
Motion favorable in a second. Now, any discussion on the bill as amended? Seeing none. The vice chair,
Yes.
Shoemaker,
No.
Anderson,
Yes.
Erican,
No.
Bartlett. Bartlett,
Yes.
Carden,
Yes.
Conway is excused. Cox,
No, and if I may explain my vote.
sure.
Thank you, Mr. Chair. I just want to draw the committee's attention to the amazing speech from the Baltimore City delegate yesterday, and would ask everyone weigh those considerations. Thank you.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes, and I would like to thank the committee so much for the journey on this bill. I've been working on it since I entered the MGA, so it's been 4 years. And I'm very thankful to all of you, whether you agree or disagree, for being on that journey with me. Thank you.
Delegate Grammer,
No.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
No.
Munoz,
No.
Shetty,
Yes.
Cham,
No.
Tolles. Tolles,
Can't see the sun is in my eyes, but yes, Delegate Fisher. She knows we had some insight about this bill. Yes, yes.
Delegate Williams,
Yes.
13, the bill proceeds to the floor. All right, we are holding House Bill 571 as there's an issue with the amendments, so we're gonna hang on to that for a second. House Bill 650. All right, House Bill 650, this is Lauren's bill. There's an amendment. All right, Lauren, I'm going to take a swing on it, and then we'll see how the committee feels. And I'll just say, workers' compensation is not something that we, Delegate Erican, you've raised your hand. Did you want to talk about something in the, you're on this bill, but later or something? And okay, that's fine. This isn't necessarily something that we deal with every day. in this committee, but we do deal with issues related to child support every day. I know that Delegate Brooks has proposed an amendment here, and I figure we could at least talk about the amendment. If people have discomfort, I'm willing to hang on to it for a day so we can get any other questions asked. But let's see where we go here. So the amendment, which is 763923, is from Delegate Brooks. He spoke to the advocates on both sides apparently, and came up with the language that would strike in the bill everything from line 9 on page 2, comma in line 9.
Do you want me to?
Oh, from the comment. Go ahead, Lauren.
I can just explain this part that
Yeah.
the amendment is striking out the list of the workers' compensation benefits that were listed in the bill, and it's substituting indemnity benefits, including any weekly benefits or settlement proceeds payable to the debtor. So with that amendment, the bill's then going to specify that 25% of the net recovery by a debtor on a claim for workers' compensation indemnity benefits, including any weekly benefits or settlement proceeds payable to the debtor, is subject to execution on a judgment for a child support arrearage. And that provision may not be construed to limit recovery otherwise allowed under the Federal Consumer Credit Protection Act.
Okay, so now Delegate Arakan has a question. We're not making a motion on the amendment yet, but Delegate Arakan, go ahead.
Just want to make sure that the amendment clears up the concerns from the opposition testimony. It sounds like it does, but there was a mention in here, that it was that the bill was excluding, a significant portion of monies that's usually paid out that could go to arrearages. So this amendment fixes that concern.
I think it does. I mean, it explicitly says the indemnity benefits, and for people who receive workers' compensation, the indemnity benefits is sort of the end of the story, is what you're getting paid weekly. In some cases for the rest of your life, in some cases, I think for 10 years. And in other cases, based on the severity of the injury. And Delegate Shoemaker is nodding his head as well. And so it kind of depends, but that I believe is where the majority of the money is coming in. And the idea behind, of course, workers' compensation is you suffered an injury at work, and we're compensating you because you suffered the injury at work. And so it is meant to be not only there to pay for medical bills and everything beyond that address that injury. It's also meant to say, okay, well, you've lost some earning capacity beyond what you would normally be able to pay because of the injury at work. So we're also compensating you for that. So with that, now we're saying, okay, well, now this person owes child support. How much of that can then they seek to garnish effectively? And that's what this bill seeks to address, is to say that of those weekly checks, that a quarter of it could be garnished for child support.
Okay, all right, that helps clear up my question. Thank you.
Yes, it is possible that the chair has a family member who has suffered an injury at work. Delegate Cardin.
Thank you, Ms. Chair. I think that the second part of the amendment, Laura, maybe you can just make sure that I'm correct. That basically what that means is that if in fact somebody is able to garnish or take that 25% of that compensation, that does not supersede another creditor's ability to be able to recover under the Federal Consumer Protection Act. So if let's just say somebody else has been able to get X amount of dollars from this person from their benefits, that would take priority over the child support arrearages. Is that what it says? Is that what it means?
I think what you were saying is correct, that it can be construed to limit recovery, that they could be allowed under the Federal Consumer Credit Protection Act. So I think you're correct.
Right, Delegate Cox.
Thank you, Mr. Chair. And maybe if Lauren wants to correct me if I'm wrong, but I think under Family Law 10-101 or whatever it is, the court has authority to already do this, to grant on a case-by-case basis the garnishment of unemployment as well as workers' compensation. So my concern is that this may tie the court's hands on a case-by-case basis, depending on somebody's issues. I mean, God forbid that somebody is in a wheelchair because of their situation. Now, all of a sudden, the little bit of money they had to buy groceries is being taken. And if it went in front of a judge, the judge would have authority to weigh those facts and to make sure that the child support is paid while also the person's not destitute. Now, I understand the amendment may correct some of that, but it doesn't seem to, it seems to tie the judge's hands specifically. Is that not true? I mean, in other words, the judge will be required to do this rather than to weigh it. Is that
Lauren?
I mean, it's saying it is subject to execution on a judgment. So it's allowed. And I think that the reason for it is that it's unclear under current law. It appears that both sides were coming in to say that currently it's unevenly applied. Different courts treat this differently. And this would lend clarity to an area of the law that is currently murky.
But I also don't think that it says that it has to be 25%. I don't think it necessarily locks in the 25%. I think that the language is clear in saying that it's subject to an execution. And I see Delegate Shoemaker nodding his head. So it may not be the full 25%. It may be something less, and I don't mean to necessarily intervene on Delegate Cox's question, but Delegate Shoemaker looks like he wanted to get in on this point. So Delegate Shoemaker.
Yeah, I mean, with regard to Delegate Cox's concern, I mean, claimant's counsel appeared and testified in favor of this bill because it does lend a certain amount of clarity to an unclear area of the law. And I would note that the 25% threshold, I guess, or ceiling is kind of consistent with Maryland law pertaining to garnishments generally. You know, if you attach somebody's wages, you can't grab more than 25%, so I think there are a host of reasons why folks from the claimants bar and folks on the other side, employer insurers bar, testified in favor of this bill. They just want to see something definitive. So that's why I'm for it.
So we're on the amendment. Can I have a motion on the amendment, please?
Move favorable.
Okay, that's fine. Any further discussion on the amendment? Seeing none, all in favor of the amendment. Again, this is 763923. All in favor, raise your hands. Delegates Howell, Cox, McComas, Moon, Lopez, Jones, Cardin, Shetty, Bartlett, Cham, Williams, Munoz, not Munoz yet, Crutchfield, Anderson, Shoemaker, Davis, and Tulls, and Fisher, and Jones. I think I got everybody. Anybody opposed? Seeing none, the amendment's adopted. We're on the bill as amended. There a motion?
Move favorable.
Motion for a favorable. Is there a second? All right. Any further discussion on the bill as amended? Seeing none, the Vice Chair.
Yes.
Shoemaker.
Yes.
Anderson.
Yes.
Erican.
Yes.
Bartlett.
Yes.
Carden,
Yes.
Conaway is excused, Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes. Oh, am I unmuted? Okay, yes. Sorry.
Grammer. Grammer. Oh dear, we've lost Robin Grammer. All right, we'll hold it open. Maybe he got knocked out. We'll let him back in. Howell,
Yes.
Rachel Jones,
Hold on. Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams,
Yes.
Grammer.
Yes.
It's 20. Okay, that's 650. Now we're at House Bill 808. Is, wait a minute, not an amendment.
Favorable.
Oh my, I don't know what to do.
Second.
That's a motion for a favorable in a second. So why don't we just have discussion about this unamended bill? There must be something wrong, Delegate Crutchfield. Here comes Delegate Shoemaker. He's got a question.
Just,
It was perfect. It was a perfect bill.
I'm sure it is.
Not for much
That's
longer. We'll find out. Delegate
That's
Shoemaker.
right. I want everybody to note this is one of two bills that have no amendments.
Yeah,
And all
I
it
see
is
that.
is
That's much appreciated. So, yeah, just refresh our recollection. What
Yes.
exactly are we doing with this?
We're
What does
just
this do?
clarifying what the courts will do when there is a guardianship, when there's a petition for a guardianship. Since there's been some problems with actually parents being able to get a guardianship. So this is all about just making sure anybody that has an interest in the child can get a guardianship, and then the court will decide through a preponderance of evidence whether that petition should be granted. And that's it.
Great. Thank you.
Subcommittee reviewed this, right? I can't remember.
No,
Oh, right. No, we didn't need to do that with this one. All right. Fine then. Any further questions on this unamended bill? Seeing none.
Mr. Chair, was the State Bar did not have any problems with this, did they?
I don't believe so, no.
No.
No. All right. There was a motion and a second. The Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Harden,
Yes.
Conaway, is excused, Cox,
Yes.
Crutchfield,
yes.
Davis,
Yes.
Lanika Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams.
Yes.
20. Okay, as we continue to move right along. House Bill 833. There are amendments here.
Move the amendments.
Motion for the amendments. Is there a second?
Second.
Okay, then let's talk about them. Are there questions about the amendments that live in the reprint 413029 written across the top? Pretty substantial amendments as it appears. And Lauren, can you talk about what the amendments do and what the bill does now as amended?
Sure. So the amendment alters procedures that the law enforcement officer and the juvenile court have to follow when there's reason to believe a child who has been detained as a victim of sex trafficking. It adds references to victims of human trafficking throughout. It adds violations under the juvenile causes subtitle to the offenses for which immunity from prosecution is provided. It expands the qualifying offenses under the bill in the current law to include unauthorized use of a motor vehicle and soliciting prostitution. And it strikes from the bill provisions relating to certain alterations to the prostitution statutes and to provisions relating to the confidentiality of child abuse records. And basically the most substantial provisions that are affected by the bill with these amendments is that it's providing immunity for a minor from criminal prosecution or from being proceeded against as a juvenile for certain offenses committed by the minor as a direct result of sex trafficking or human trafficking. And then the other provisions are listed starting in the reprint on page 4, and these are actions that a juvenile court must take when determining whether the child's actions were a result of sex trafficking, and that includes dismissal of the case if the court makes certain findings. And I'm trying to think, I think those are the two major changes.
I'm sorry, could you say those changes one more time, please?
Sure. I mean, I think the most substantial or the most important thing is that it's providing immunity for a minor from criminal prosecution as an adult or from being proceeded against as a juvenile in juvenile court for certain offenses committed by the minor as a direct result of sex trafficking or human trafficking. And the offenses are the qualifying offenses that are in the reprint on page 5 in criminal procedure section 8-302, and then violations under the juvenile causes subtitle. And those are basically offenses that can really only be committed by an individual under 21, or in at least one case, 18. And then sex trafficking.
All right, let's hear from questions now. We'll go to Delegate Shoemaker, please.
Was there any opposition to this bill? Because I don't seem to recall if there was. I guess prior to the amendment.
One moment, please.
Well, thank you.
The state's attorneys were opposed and testified in opposition. It's my understanding that the judiciary was opposed. My understanding that the sponsor worked with the State's Attorneys Association, and I did receive a call from the State's Attorneys Association telling me that they were okay with the changes that they had spoken to the sponsor about.
Okay,
So I believe it addresses their concerns.
thank you.
All right, the vice chair, please.
That's all. I was just going to say, I understand there's no opposition with the amendments, and
That's my understanding as well. I think it has addressed their concerns. And in fact, I believe I've seen a letter saying that they support the bill as amended. Delegate McComas.
Yes, Mr. Chair. What about the courts? Are they cool with it now, or they're just not going to like it no matter what's done?
Is that a rhetorical question?
You laugh. You laugh. How can you laugh at me?
Well, you know, the courts, the courts honestly raise important issues a lot. They do. They genuinely do. And now I'm going to be nice a little. And they do. I don't know whether they've seen.
I'm reading your mind.
I don't know whether they've seen these amendments or not, and I don't know whether their position has changed. And I'm not totally making light of the fact that they do raise important issues, and the issues that come into play as we act and as they act sometimes conflict, and that's part of their job to express that. So now that I've been nice, no, I have no idea whether they're okay with it. All right. Are there any, and although it's possible that I'm hearing from the sponsor that the sponsor is going to work with the judiciary. And so perhaps as this process continues, even that opposition may be vanquished. Who knows? But I think for the moment, the state's attorneys are on board, and they were the ones who came in and actually talked. So there it is. So we're on the amendment. Is there any further questions about the amendment? I don't see any. All in favor of the amendment to House Bill 833, please raise your hands. That's McComas, Shoemaker, Moon, Howell, Jones, Shetty, Lopez, Bartlett, Cham, Williams, Carden, Tolles, Davis, Crutchfield, anybody, and McComas, anybody who is opposed to the amendment as offered. Seeing nobody is opposed, the amendment is adopted.
Favorable.
And there's a motion for favorable. Is there a second?
Second.
Thank you. All right. Any further discussion on the bill? Any further questions? Seeing none, the vice chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
okay, Bartlett,
Yes.
Carden,
Yes.
Conaway.
Yes.
Oh, hello. All right. We're glad to hear you. Cox,
No.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Sorry with the button. Yes, Mr. Chair.
Grammer,
Very respectfully, no.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams,
Yes.
19. All right. We have a Howard County delegation bill.
Hmm.
Not sure who gave that reaction, but that's fine. House Bill 868. This does not have an amendment.
Move favorable.
For a favorable, is there a second?
Second.
And a second, okay. All right, so we're on House Bill 868 we have a letter from the Howard County delegation. Are there any questions? Oh boy, here they come. Delegate Anderson, then Shoemaker.
Yeah, I understand you have a question. I mean, you have an answer. I mean, a letter from the Howard County delegation. Who testified against this bill? Do you have that too also, Mr. Chairman?
One moment, please. Ann Dodd, who I believe is one of the orphans court judges.
And they have 3 orphans court judges,
Yes.
and the
And
judge,
in candor, I think we've also received an email from one of the other Howard County orphans court judges. Yes.
was that Judge Turner,
I believe that's who also contacted the office. Yes.
former Delegate Turner's wife?
Former Delegate Turner's ex-wife.
Oh, okay, that changes things. No, I'm just kidding. I'm just kidding. I'm just kidding.
Does it? Okay. Great. Do you have any other questions, Delegate Anderson?
No, I'm sorry. Can you delete all that?
No.
Redacted or something?
No, we can't do that either.
Oh, gosh.
I have a question, Mr. Chair.
Well, Delegate Bartlett's in front of you, so we're going to let Delegate Bartlett go first, and then we'll do that. And I'm sorry, we also, wait a minute, I did call Delegate Shoemaker, who put his hand down, which throws off the whole system.
Sorry.
Delegate Shoemaker, then Bartlett, then Fisher.
Thank you, Mr. Chairman. I mean, generally, I don't care what they do in Howard County or any other county for that matter. But, because I believe in local courtesy, but sometimes actions at the local level have state repercussions or, potential repercussions. And for some reason on this Howard County local bill, I've been getting a lot of flack, and I think I alluded to that. And maybe some other folks have too, I don't know. So it's kind of concerning in that regard.
All right, let's hear from other people and see where we are. Delegate Bartlett.
Strangely enough, that is what I was going to say. Because actually I did get calls from my Anne Arundel County Orphans Court folks, and they are afraid it would have a ripple effect. However, I did notice that currently I think there's only 2 counties that do this. Was it Montgomery and somebody?
Howard.
Montgomery and Howard. No, Montgomery
Hartford.
and somebody.
Hartford.
Hartford. Okay.
So it's Montgomery and Hartford, and, we still have, 21 jurisdictions to go before it really becomes an epidemic or anything. So, but I did get calls, and on both sides of the aisle, just to let you know, for Anne Arundel County, asking not to support the bill.
Delegate Fisher.
Hi, Mr. Chair. Sorry for not waiting my turn. I just had a similar question. So in the bill on line 10, page 3, it says this subsection does not apply to Hartford County, comma, we're adding Howard County or Montgomery County. So you're saying that those two counties don't do that election, right? But everyone else does? Which is kind of Delegate Bartlett's question, but I'm just trying to clarify.
Yeah, my understanding is it would add Howard County to the lists of subdivisions who effectively just send their matters directly to circuit court.
Okay. Okay.
Yeah.
I wasn't really contacted the same way Delegate Shoemaker and Delegate Bartlett was, but I was just concerned about it, that we're having a different way. I do believe in local courtesy, but I do think when one enters the criminal or civil system, I believe it should be a system that you enter throughout the state in order to seek justice. And so, I mean, I'm not super comfortable, but it is local.
Well, I would say, and there are already 2 counties that do it this way. So this isn't like the first time that this has happened. This is a choice.
And do you know the history as to why Montgomery County and Harvard do it that way?
I don't. I have the vice chair with his hand up, but I'm not sure if he knows the history necessarily either. But I'll just say I don't know that. I believe there was a unanimous vote from the entire House and Senate Howard County delegation, however, on this point. So, I mean, it's clear that other delegations have done this in the past, and there appears to have been local courtesy offered to them. Let's go to the vice chair.
Thank you, Mr. Chair. I can't bring any insight as to Montgomery County's journey on this question, but I will just say this doesn't strike me as an improper local bill subject matter. And frankly, if there was a delegation letter from Howard County on this, I would vote for the bill. And if the delegation didn't support this change, I would vote against the bill. And encourage folks that if the question came up for their county, that we would do the same. That if Hartford County did or didn't want to have this system, it doesn't strike me as the type of subject matter that impedes through slippery slope other counties. But that's just my 2 cents.
Delegate Arikan, representing Baltimore and Hartford County.
I was just wondering, on the vote in delegation, do we have that vote? Was it unanimous?
It was unanimous. And my understanding, is anybody here at Harvard? No. My understanding is they all vote together. They all, I actually, hold on.
Always?
One moment, please. No, I'm sorry.
No, he means.
I've got this. They vote as senators and delegates, and I'm looking at the voting sheet, and I will say that it did pass. However, it was not unanimous. The vote that I see here had the following in favor: Delegate Watson, Senator Gazone, Senator Hester, Delegate Atterbury, Delegate Ebersol, Delegate Feldmark, Delegate Novotny, Delegate Terrassa, and in opposition, Senator Lamb, Delegate Hill, Delegate Kittleman. There were 8 in favor, 3 opposed. Delegate Pendergrass was excused.
Weird. What a weird vote. Okay. That doesn't help me at all, but thanks.
No.
Well, there you go. All right. Delegate Munoz, please.
I just want to say, just responding to a few of the comments we've heard, I absolutely want to respect local, county delegations and what they want to do, but I've received a lot of phone calls from Anne Arundel County asking me not to support this because they're very concerned that this is, it is, a slippery slope, like someone mentioned. And hearing the background that there's 2 counties that do it, now this is a 3rd, it actually kind of makes more sense that they might be trying to eliminate orphans courts
Yes.
throughout the state. And yeah, so just to support my own orphan courts judges, I'll be voting against it for that reason.
All right, I'm gonna just say it feels like there's a little bit of unsteadiness here, and I know, well, and Delegate Anderson wants to say something, so my inclination right now is to hold it and we think about it a little more, but let's hear Delegate Anderson's taken down his hand, so.
Or if you're going to hold it, then I'm not
Yeah,
going to.
I think I'm gonna hold it a day, and and since I think there are people who are hearing from people on both sides, I think I'd like to,
Hey, Mr. Chair,
take some more. Sure.
Were there substantive reasons for doing this at all? I mean, or was it just, I don't know, political?
No, are there substantive reasons? This is a local bill.
Right.
I mean, this is ultimately, I mean, just to be clear as to where the chair's position is, I mean, this is a local bill. It's a decision that has been made by the local delegation. They want to go in this direction. For me, to some degree, that's where the story ends. I mean, whether the policy choice is right or not, they're choosing to go in a different direction. And so I mean, for me, that's fine. What I'm willing to do is hold on here and well, we're going to have some more people talk here, I think, in a second, but what I'm willing to do is hold on here just a little bit and make sure one way or the other, that again, on a local bill, if people really do have this level of discomfort, I don't want to make things harder than it needs to be, I guess.
Okay.
So anyway, let's hear from some more people. Delegate Rachel Jones.
Thank you, Mr. Chair. I have a question, and anyone could answer or clarify it for me. It's my understanding that because is it true that the orphans court is really the only court where you don't have to have any type of legal background? You don't have to be an attorney. You can be elected to make decisions about the children of this state without having any type of legal background. Is that correct?
Well, orphans courts don't actually deal with orphans.
Okay.
It's one of the parts. They deal with basically their estates and trusts.
Yeah. Okay.
So they don't deal with kids. And so some jurisdictions do require that orphans court judges are attorneys, and that includes Baltimore City. Delegate Anderson was nodding his head. There are some jurisdictions that have required that, and some who have not. So it's not the case that every single one are not required to have a law license.
Well,
Okay.
Mr. Chair, Prince George is where you rep Rachel is.
Sorry, Delegate Tolles, what were you saying?
I'm sorry, Mr. Chair, for jumping out of line. I just wanted to also indicate, since Delegate Jones, like myself, represent Prince George's County, it should be noted that they do require an attorney, the only 2 jurisdictions that do.
All right.
Thank you. But so for this bill particularly, this would ensure for Howard County residents that those judges actually had some sort of legal background.
Yeah, they'd be circuit court judges. They would just move the docket to the circuit court bench as opposed to having a separate orphans court.
Thank you. I just wanted to clarify. Thank you.
Delegate Cardin, then Delegate Davis, then Delegate
Thank you,
McComas.
Mr. Chair, I was the sponsor years ago of the Baltimore City bill that required orphans court judges to be attorneys. And then I was subsequently the sponsor of the Baltimore County bill because we had a particular judge who needed to be in a different position because the workload, she could not handle the workload. That being said, I believe that Howard County also required their orphans court judges to be attorneys, but maybe they didn't, and maybe that's why they're going this direction. I'll just say, just in case you're taking notes, Mr. Chair, that I believe that even if it's a bad policy decision on their part, this is local courtesy. They can choose to do it, and other counties can lobby as they will for their own delegations to choose what they want to do or not do. So I think let them choose how they want to go forward, and I will support the local courtesy.
All right, Delegate Davis.
Thank you, Mr. Chair. I agree with Delegate Cardin that it's a local bill. And if they choose, for whatever reasons, if they choose to move in this direction, that's up to them. They have to afford it. They have to be able to fit it into their court schedule. And one thing that you learn from being a state delegate and a local official is that the people that have been calling my colleagues, they need to call their local people. They need to call their local county exec, their local county council. That's who will make the decision, because if they don't sign a letter, they'll never get this. That's the checks and balances.
All right, Delegate McComas.
Yes, Mr. Chair. I was just gonna, I think Delegate Cardin did a good job explaining it. Because I recall that Baltimore City, they required them to be attorneys, and I was around when that was done. And that may be the fix that would calm everybody down. I think we need to know if the judges are attorneys or not in Howard County, and why they're moving to this. In other words, there's usually a reason for it, as opposed to that maybe no one articulated to us. I don't know.
Delegate Cox and Williams.
Thank you, Mr. Chairman. I just wanted to let the committee know that my view is that it's not a local courtesy bill, because this is in fact a constitutional amendment. It has to go before the voters, because the Constitution of Maryland requires orphans courts. So this is going to go before the voters on the ballot. And I think therefore we need to exercise discretion. And since it's not unanimous below, I think constitutional amendments, when it rises to that level, really should be unanimous for a county when you're stripping something away, from that county, because the voters, it's taking a vote away from the voters. So anyway, that's just and also having practiced before the orphans court, as well as the circuit courts, I can see the value for estates going before a separate, smaller body and not being clogged up in the system. I've always had a much more positive experience in the orphans court for different clients to streamline it and to get it done. So that's just my thinking on that.
Delegate Williams, then Delegate Bartlett.
Thank you, Mr. Chair. I wasn't going to speak since I thought we were holding the bill, but now I feel inclined to speak as vice chair of my county delegation, where we have had some county-specific bills that our county has voted in favor of, most notably one bill sponsored by my good friend Delegate Juanita Fisher, that the General Assembly has not seen fit to move on. If we're going to have this conversation about local courtesy, it would be great if we could have this conversation about local courtesy across the board, and certain priorities from my county we would love to see pass. And so for that reason, I'm in favor of this bill, because I do believe in local courtesy and would love the same to be treated to my county.
For the record, I believe that more people have spoken on this Howard County bill than could have possibly spoken on the bill in the Howard County delegation at this point. Delegate Bartlett.
That is true, Mr. Chair. So I wanted to ask, with respect to the constitutional amendment, would it be just the Howard County voters who would receive the constitutional amendment?
No, actually,
I'm seeing yes and no.
I believe, according to the language in the bill, that is put before the voters of the entire state of Maryland.
Plus, it has to have a super majority vote in the House of Delegates and the Senate.
Right.
The MoCo change was on the ballot. I remember that.
Yeah.
What did Vice Chair say?
When Montgomery County did this, it was on the ballot. So this was question whatever, D or something.
Okay, I gotcha. So this is really the question before us is more like, do we want this, should we just put this on the ballot? I'm going to go ahead and I plan to vote favorably because like I said, I don't see it as an epidemic just yet. There are only 3 jurisdictions, and no one in my county has asked for it. So it's
Yeah.
local courtesy in a way, but also the fact that it's going to be the local voters who are going to make that decision. And I think that kind of does it for me.
All right. By the way, my understanding is you do not have to be an attorney. And that I believe one of the attorneys on the local orphans court right now in Howard County is not a lawyer. So you do not have to be an attorney to be an orphans court judge in Howard County. Again, continuing the vast discussion on this local bill is Delegate Grammer.
Thank you, Mr. Chair. Just a couple brief comments so anyone watching has a feel for what we're talking about here. So I have had a local Baltimore County bill that I've sponsored for 8 years in a row now, because in that first year, a delegate from a different jurisdiction amended it, and I just can't get it across the finish line now. I have local bills in several committees. We've passed them through the House. We've passed them through the Senate. Can't get it done in the same year. So I wish this rule applied unilaterally. I think it's a sign that this bill came out of the delegation with, for the record, both Democrats and Republicans voting no. And I think for things like this, like I'm getting calls in Baltimore County about this. And it's just sometimes it's a sign you just, if you feel weird about something, you vote no. And that's also in Annapolis here, you get afraid to vote no because you offend another person. I think sometimes you just got to stick with your principle. And I think that's why some of the folks here today might be voting no.
Okay. Quite a bit of debate. I think what I'm inclined to do is just hang on. It was a local bill, and at a minimum of local courtesy, I'm going to speak to the sponsor, or at least the delegation sponsor who brought it here, and then we'll come back to this tomorrow. I don't think there's anything wrong with that. We have plenty of time, so that'll be fine. We will come back to it, and I do appreciate all of the conversation that we've had, again, with more people talking about this here probably than talked about it in the Howard County delegation. I am going to go past 965 right now. I'm going to go now to 1062 because we've talked a little about 965 in the past. I'll come back to that here in a second. I'm going to go to 1062, Delegate Moon's bill, and there is an amendment. Delegate Moon or Holly, or I'm not Holly, or Lauren, you want to talk about what the amendment does, please?
Just a one-word amendment. It's a fairly technical change that just changes the timing of when the proceedings in the bill occur.
Okay. All right.
I'll move the amendment.
Let's move and second the amendment. That sounds fine. Now we'll take questions on the amendment. We'll go to Delegate Grammer.
I didn't have a question. My hand was still up. Sorry.
All right. Does anybody have a question on the amendment? Seeing no questions on the amendment, we will take a vote on whether to accept the amendment. All in favor of the amendment, please raise your hands. Delegates Grammer, Bartlett, Williams, Anderson, Jones, Cardin, Davis, McComas, Munoz, Moon, Fisher, Shoemaker, Crutchfield, Cham, Lopez, Shetty, Howell. Anybody opposed to the amendment? Opposed to the amendment? Seeing none, the amendment is adopted. We're on the bill as amended. There's a motion for a favorable. Is there a second? There is. All right.
Can you explain the bill one more time, please?
The Vice Chair, please, to explain the bill as amended.
It basically creates a process where when animals have been impounded in a cruelty case, while the case is happening, it creates a process to charge fees that would pay for basic food, boarding, and veterinary care for the animal. It caps it at $15 a day for the food, $50 for the vet care, and it excludes livestock and things of that nature, and otherwise provides a mechanism if the person is found innocent to get their money back. It creates some process for them to get advance notice that their animals have been impounded, to request a hearing, to get them returned or to modify the amounts. Yeah, and if they want to avoid all of this at any time, they can relinquish the animals.
And how long does that last? Is it just for until the hearing is concluded, or is it they have to pay for their costs indefinitely?
Well, it's during this case.
So it's a limited time.
Yeah.
Thank you.
All right. Any further questions on the bill as amended? Delegate Bartlett.
I just have one quick question. I was looking at the testimony from the American Kennel Club, and I just wanted to, does the amendment address their concerns about the loss of animal ownership for failure to make the, hold on one second. Let me get more specific on it. The main thing that they were concerned about was that people who treat animals in a cruel manner should be held accountable and punished accordingly. That already exists, right? I mean, we know that. So
yeah, this doesn't really get at what the penalty should be if you're found guilty. It's really, the problem is you have these hoarding cases and things of that nature where, and you know, probably the defendant might not be right of mind, but they're not relinquishing rights to the animals. The animals do have to be cared for. There was some indication of abuse or neglect, and so they were seized or impounded. And now there's going to be a year-long case where the local taxpayers are on the hook for this, but the person refuses to relinquish rights, and you know, in some instances couldn't pay for the care in the first place, which is how they ended up there. So this bill has been around for years. I think this is as slim as we've seemingly got it. And you know, if it makes you feel any better on lingering concerns, I'm hearing murmurs that the Senate may go to work on the bill as they like to do. So
Delegate Delegate Cox.
Thank you, Mr. Chairman. I just want to tell the committee this is the guilty until proven innocent bill that we've killed before. I mean, the problem that I see with this bill, as we've heard testimony about, and practically local experience from Washington County, is that it creates an incentive for charging people who have not been found to be neglectful of their animals, and allows an incentive for neighbors to capture their neighbors' cats and dogs, take them in, get a remuneration for it. And then what was happening, this is going on in Washington County, what they then charge these enormous fees to get your animal back. And they do this in a cycle. This was exposed by an undercover officer in Washington County. I understand the concern about the burden, but you know what? There's already a remedy in the law. So if you're found negligent and guilty, then you can be ordered to pay those amounts. So I think we need to keep it as innocent until proven guilty. And so that's why I'll be voting no.
Delegate Erican, then Grammer.
I hear my friend and the good delegate from Frederick. I would just say in terms of, you know, civil versus criminal, we have cases where people either can't be tried criminally or are not found guilty criminally because it's a high bar, but the victims' families are still able to sue civilly. And, you know, I believe a good example would be O.J. Simpson.
Delegate Grammer.
Thank you, Mr. Chair. And I think Delegate Cox kind of articulated the uneasiness I have in the back of my head about this. Can you tell me, Delegate Moon, can you tell me what's the precedent we have here? What is there anywhere else in law or in a different system where we have this kind of setup where we might put in place a petition where we could require a person to pay the cost for a service, while they're under the allegation of an issue?
yeah, I mean, so number one, part of the genesis for this bill is that many other states already have this process in place, including our neighboring states. So it's not at all foreign in that respect. So we are really joining both our neighbors and other states. I think the framework that you should think about is, essentially you're posting a bond for something while that something is in dispute. If this were a car or something like that was impounded, you might have tow and storage fees. But again, what we're talking about here is it's a living creature, and so it's not like ordinary property in that regard. Someone's going to be eating the fee there. And you're right. Years ago, we had a bill. It was my bill. I think Senator Reedy had it across the street, and it authorized judges, which they already had the right, but it tried to spell it out for them to insert these fees at the conclusion of trial upon conviction. And so we already tried this. To Delegate Cox's point, we already tried this method of let's wait till they're found guilty. And this is what led us to all these problems where basically these local the shelters are not being compensated. So I think you'll find that across the state, the local shelters and humane societies in your own community are requesting this bill. Again, we tried it this other way. The judges are not ordering the fees. And so the taxpayers end up on the hook for this with, again, some fairly potentially mentally ill people who aren't relinquishing animals in a hoarding case with 100 cats in the house.
Thank you.
Delegate Williams.
Yeah, Delegate Grammer's comment made me think about something. I think Delegate Grammer was asking, are there any instances where we charge people up front? I'm just thinking about like kind of in a criminal situation where someone has an ankle monitor in some jurisdictions, they have to pay for that. Even though they haven't had their trial yet, they haven't been found guilty yet, they're having to pay for this service, during pretrial because of the situation. So I don't know, that was just a thought that came to my head. Isn't that so? I guess, Delegate Moon?
That's correct. And thank you. I will actually say, not only that, I had a bill a few years ago to refund your ankle monitoring fees if you were found not guilty. It did not pass.
All right. We've had, okay, we voted on the amendment. We did that already. So now we're on the bill favorable with amendments. Had plenty of discussion. Any further discussion? I see Delegate Erica and Delegate Williams electronic hands still up and they're not. Yes, fine. All right, do a roll call. See what happens. The Vice Chair.
Yes.
Shoemaker.
Yes.
Anderson.
Yes.
Erican.
Yes.
Bartlett.
Yeah, yes, and can I explain my vote?
Sure.
Because we should be paying for ankle bracelets.
Okay.
Sorry, Mr. Chair. It was just a shout out.
I'm suffering whiplash because we're on an animal cruelty bill and I just visualized the GPS monitor on
a collar, GPS collar
on Mittens the cat. All right.
Mr. Vice Chair knew what I was doing.
Okay. Swell. Cardin.
A very strong yes.
Conaway.
Yeah.
Cox.
Very strong no.
Crutchfield.
Yes.
Davis. You're muted.
Yeah.
All right. I heard yes.
Yes.
Okay. Juanita Fisher. She here? She was here. There she is. Delegate Fisher.
Sorry, yes.
Grammer.
Very respectful no.
Howell.
Yes.
Rachel Jones.
Yeah.
Lopez.
In honor of Mittens, yes.
McComas.
This is about the critters, Bill?
Yes.
Absolutely, yes.
Munoz. Munoz? She stepped away. We'll come back to her. Shetty,
Yes.
Cham,
I'm a yes.
Tolles,
Yes.
Williams,
And yes, and I think David should bring his bill back next session.
Delegate Munoz, you there? She just stepped away for a moment, I think. All right, Delegate Munoz is not voting.
Did it print out?
Looks like
Oh, wait,
Delegate
there
Munoz.
she is, Delegate Munoz for 1062, the Vice Chair's bill on costs for seized animals.
How did my minority?
I will tell you that everyone is a yes except Cox and Grammer.
Yes, please.
Okay,
Thank you.
19-2. We're going to go now to House Bill 1248. House Bill 1248, shockingly, with this docket, has an amendment. Let's hear from Lauren. It's a 5-year sunset, right, Lauren?
That's right. That's all it does.
All right, so all it does is a motion for the amendment. Is there a second?
Second.
Moved and seconded. All in favor of this amendment, unless, well, wait, does anybody want to talk about whether there should be a 5-year sunset on it? Okay, Delegate Williams thought about it, but no. All right, all in favor of the amendment, please raise your hands. Delegates Moon, Davis, Cardin, Bartlett, Munoz, Anderson, Cox, Jones, Howell, Shetty, Lopez, Cham, Crutchfield, Grammer. Anybody opposed? Seeing none, the amendment's adopted. We're on the bill as amended. Motion on the bill.
Move favorable.
Is there a second? All right. Any further discussion on this bill? Seeing none, the Vice Chair.
Yes.
Shoemaker,
Yes.
Anderson,
Aye, Captain.
Erican,
Yes.
Bartlett,
Yes.
Cardin.
Yes.
All right. Conaway,
Yeah.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Wanika Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Oh, so let me,
Tolles,
Yes.
Williams.
it says 4.
Williams?
In this is.
One moment.
Yes.
All right, that's 21. All right, House Bill 965. We talked a lot about this before. I believe did we adopt the amendment? There are 2 amendments. I thought we adopted the amendment. We already adopted the amendment that made it 15,000. If I'm not mistaken.
Yes, that's right, Chair.
Okay, so we adopted that amendment, which was 743928. Delegate Davis has submitted an amendment.
Yes.
And probably on the initial reading of the bill, but that's your amendment would add language, but didn't do anything on the dollar amount.
No, it didn't, Mr. Chair.
Okay, all right. So committee for delegate, I'm going to make a ruling that on 603-622, which I think was drafted to the original version of the bill, I'm not going to rule it out of order. Then don't really need to make a bigger deal than I need to, because it mentions the 25,000 and now we're down to 15,000. I just would say all it's doing is it's adding language to it. And so that's the focus of the amendment. Don't care that it was set up to the other bill. Delegate Davis, would you explain what your amendment would do?
Yes, and thank you for an opportunity to talk about it some more. You guys know I felt a little uncomfortable with it, so I thought about guardrails that we could put on this bill, perhaps to make some of us feel more comfortable. And this guardrail is, it just adds a sentence that says that the amount of recovery is limited to the damages not covered from another source. So this would mean that you would not be able to profit from the injury of your animal. If you had insurance, the insurance would pay. The person who was liable would only pay for what was over the damage to the pet, so that you wouldn't be the person wouldn't be able to profit. And I would just want to go back to some of the stuff that Delegate Cox mentioned. I mean, the idea that you could take a dog and I don't know, a stray dog and make some money off of it because somebody injured it. I think if you believe your dog is worth $15,000, you should insure it, and you prove that it's yours by insuring it, and you have an interest in it, and that you shouldn't be able to make money off of it. So I move the amendment.
I don't hear a second.
Oh, you need a second. Second.
Yeah.
There's a motion and a second. Now we have discussion on the amendment. Delegate Grammer, then Moon, then Williams, then Cardin.
Thank you, Mr. Chair. Can we just have a discussion for the non-lawyers, non-attorneys on the committee? There's a lot of different types of damages that a person can get under any claim. And I don't think that insurance is typically factored into those kind of damage limits, but I'm not also 100% sure of that. So can someone maybe who's more familiar with these kind of claims help me more clearly understand?
If I may, Mr. Chair?
Yeah.
It's kind of what I do for a living.
Go ahead.
Damages, there is a, oh my gosh, I just totally lost it. There is a clause, collateral source clause, that says if you as a human being are injured and you have insurance, that you actually could collect from both sources.
So understanding that you could collect under your insurance as well as the damages.
Yes, so you could, and so the public policy behind it is we don't want to penalize you for having Affleck, right? Or
Right.
for you for having PIP. We want to encourage you to have PIP insurance.
Right. So under this bill, why?
I'm sorry, that's personal injury protection insurance. I'm sorry.
Sure. So if we had, this bill if we have these damages and a person had insurance in that particular case, why would we limit, why wouldn't a person be entitled to that if they were entitled to compensatory damages and they had insurance?
They are not entitled to compensatory damages. Isn't that how we amended the bill? To non-compensatory damages? But well, for the reasons that I mentioned, that I don't think you should be able to profit from it. I mean, it's not a human, it's an animal.
To be clear, I'm sorry, very briefly, Delegate Davis, there were two different bills that were brought forward. One of them dealt with non-economic damages.
Non-economic.
And that is not this bill. This bill doesn't talk about that at all. Just being clear, because I don't want to confuse it. That bill is over on the side. So they were brought at the same time. So that's why I wanted to stop the train right now, just to make it super clear. We are not dealing with non-economic damages here. And I apologize, and go ahead, Delegate Davis.
I think I'm done. Did I answer your question, Delegate?
Yeah, I think I understand. Thank you.
The Vice Chair.
Sorry, so I'm just trying to understand this amendment also as clear as possible. Does this get at the issue about, I remember in past debates about insurance and liability, there was an argument that I tended to agree with, that if I paid for insurance, two insurance lines, essentially, that there were scenarios where, well, that was the gamble I made. I've been paying $100 a month, for these people in the event that something happens, and that there's an argument to be made that I ought to be able to collect from both insurance lines. Are you getting at that scenario where if my actual insurance, if the healthcare bill for my pet was $10,000, that you're trying to stop me from collecting $10,000 twice?
Absolutely.
Or is it a different issue?
Absolutely. Well, I'm
Or would
yes,
it stop me from
this-
getting the 10,000 once?
No, well, hold on. It would stop you from getting the insurance return and another $10,000. So that's 2,000, that's 10,000 twice. So you'll be actually profiting because your actual damages are only 10,000.
Is that what you mean by the amendment, though? That
Yes.
that if the chair hits my dog accidentally, whatever, and injures it, and I got to take it to the vet, and the vet hands me a bill for $10,000. I also happen to have insurance of some type for this, that you want to stop me from suing the chair for $10,000 and also getting $10,000 from State Farm?
Absolutely.
And is there anything else that this amendment does? I guess I'm just trying to understand.
No, it simply reads that your limited damage is not covered by another source.
And I guess my other question is, how do we handle this in other civil claims? But I'll put my hand on it. Since
With civil claims with humans, we don't have this clause.
We
have a collateral source. We have a collateral source rule that allows you to collect both.
All right. Maybe I'll leave it to the subcommittee to fill in some gaps here.
We'll go to Delegate Cardin.
Thank you, Mr. Chair. Not only do we have the collateral source rule, but there's scenarios, I believe, where you can't even know in court what you've collected from a collateral source. So a jury wouldn't, or a judge would know, but a jury wouldn't even know. For example, if I was injured personally, and I'm suing for $100,000, and I got compensated by my insurance for $50,000 of that. This is for medical bills, and this is for the costs that I've had to incur. The jury wouldn't know, they're not allowed to know that I collected that $50,000 because it could make them say, well, he doesn't really deserve to be compensated to make him whole again because he's already gotten half of the money. And I think that is the issue that we have here is that if there was wrongdoing, in my opinion, and somebody's pet was injured, that they should be able to collect, and this is only for the economic damage. This is only for what they have. They're not even allowed to get other damages. So they should at least be able to collect from the wrongdoer the amount that they were out of pocket. And as far as insurance is concerned, with all due respect, Delegate Davis, because I understand your position, I just disagree with it. It is that I could have been spending thousands of dollars in insurance over the course of my dog's life. And then when she's 10 years old, I've spent, thousands of dollars. And now all I'm looking to do is I collect a couple grand for the insurance claim after I've already spent much more than that. So I don't think it's fair to say that you're getting that it's apples and oranges. I don't know if I'm coming out clear. That was sort of jumbled. I apologize, but I think that there's two different things going on here. I just don't think the amendment is the right way to go. I understand it. I'm just going to vote against it. But it is, the intention is good. It does what I would want to do.
Delegate Williams, then Erican, then Bartlett.
Thank you, Mr. Chair. I think I get what Delegate Davis is doing. I guess my question, and I'm not an insurance expert by any stretch of the imagination, would, in the scenario that you're talking about, I have insurance on my pet, the insurance company pays out $5,000, and then I file a lawsuit against someone for the $5,000 worth of economic damages for the vet fees for my pet. Would the insurance, I guess my question is, would the insurance company have a right, I guess a subrogation, to collect that $5,000, since that's the $5,000 that they paid out to me. And I guess my concern is that, does the language in the amendment preclude the insurance company from being able to do that? Because I guess that's why, I don't know. I guess that's where I'm a little confused.
So there is a subrogation right. I can tell you that. Now, I guess it would depend on your policy. I don't think it would preclude your insurance.
Because you're saying they can collect twice.
They can only collect, no, they can only collect damage that are not covered by another source. So if you have insurance that you can get, if your damages to your animal was
extra. Well, but
yeah,
wait
you
a
can only
minute.
do extra.
But so if the insurance covered it, but now because the insurance covered it, I can't bring a claim against the tortfeasor because the insurance covered it. So now the insurance, you don't even get to the subrogation at this point, do you? You don't even get to subrogation because the insurance company can't step into your shoes.
And that's what I was getting at. The insurance company wanted to come in and sue. Sorry.
That's fine. I'll let me try and state it one more time clearly, and then I'll go back to Delegate Williams. I mean, so if you're limited to damages not covered by another source, so under I think the vice chair's rather mean example where I hit a dog. So I hit the dog, it's his dog. My insurance covers it, but I'm never found to be liable or I'm never found to be liable for the injury to the dog because nobody's ever, I've never lost the tort claim. So, and I can't be held liable under tort because the other source has already covered my costs. So now how is the actual, I'm missing, I feel like I'm missing something. Delegate Williams, I'll send it back to Delegate Williams and then Delegate Davis.
Oh, I'm tempted to send it back to Delegate Cardin. I guess my question is, okay, if the insurance company pays out, would the language preclude the insurance company from suing the person that hit my dog? I'm not suing the person that hit my dog. The insurance company wants to recoup the $5,000 that they paid to me.
I don't know. What makes you think that it would preclude the insurance company? I'm not following it.
Delegate Cardin.
If your insurance, in your example, Mr. Chair, if your insurance covered it, they would require the plaintiff to sign a waiver of rights to sue you. So that's the issue is if you get it from another source, it wouldn't be from, because that would be the same source as the defendant would be the defendant's insurance company. If you got it from your own insurance company, or if you got it from, let's just say for the sake of argument that you held some sort of policy that life insurance policy that covers injury to your pet or something like that. And so you got some money there. The amount that you could claim, I believe, according to Delegate Davis's amendment, would be reduced. And that would also, by the way,
Delegate Bartlett, we can hear you. Delegate Bartlett, thank you.
Okay, that would also interfere with if Delegate Moon's insurance company did cover the damages, and then Delegate Moon wanted to sue you, his insurance company would not be able to subrogate. You're correct, and that therefore that could cause. I mean, I think that's unfair that they can't recover from the actual tortfeasor.
Right.
Yeah, I do. You can't be more specific than what I do is subrogation. There's nothing that would stop the insurance company. Well, aside from the fact that you have an agreement with your insurance company that they can't subrogate, but there'd be nothing there that would stop an insurance company from subrogating for what they paid. Is that part of it?
Where would they get the money from? There's no other money coming in because you've barred the ability for other money to come in.
Subrogation is just what they paid. You understand? Subrogation is the whole concept of subrogation is the insurance company paid it and they're getting it back. That's the whole concept.
All right, let's do this. Delegate Arakan has been waiting, along with Delegates Bartlett and McComas. So let's hear from Delegate Arakan, and then we'll go from there.
I was just going to say, it feels like a lot of people are uncomfortable with the amendment, so I'll just move the previous question.
The other two have raised their hands. I take that. I appreciate it. But let me go to Delegate Bartlett first, and then Delegate McComas, and then we'll go from there. Delegate Bartlett.
I think this is a very novel concept. I actually do. But, the only thing that's different, and I'm not going to compare it to human, I'm going to do more like property value, because that's really how the law defines. But the thing that's different is you could still get the non-economic damages. And I don't want to go there because I know we don't have that bill anymore. But where we're going dollar for dollar, that changes things a little bit. But this is a very novel idea. So here's my question. Two questions. Where does the insurance come from? Hopefully you can hear me okay. I'm sorry, I was leaning back. Where does the insurance come from? Is it your home insurance, or what insurance would cover, what type of insurance would cover this?
So I believe you'd have to buy your own personal insurance company. Your insurance company, your homeowner's insurance company covers you for liability if your dog bites somebody. And if you're negligent, your insurance company could pay the damage also for someone else, but it wouldn't protect your dog. You with me?
Right, but see, that's what I'm saying. When we say damages by another source, what would be that another source? That's what I'm trying to understand.
That would be the person who owes you, the person who caused the damage negligently, caused the damage to your animal.
But
if that person was insured, only if they were insured.
Oh, right, okay.
Right. But
Yeah,
I think it also stops people, stops me from picking up a little stray dog off the street and saying, Sandy, you damaged it. And, I don't even have any skin in the game because I don't even insure my own dog. But, would you feel a little bad if you hit some stray dog and you realize that somebody was pulling a scam? I don't know.
Well, yeah. Okay. So, but like I said, I do see it. I see it as a novel idea. I wish there was some way that we can kind of flush it through, because it sounds like what you're getting at is you want the property value aspect of it. So let me ask you one more quick question, Mr. Chair, if it's all right. And that is, okay, so let's talk about the personal injury protection with not personal injury. Let's talk about your car. It's been a while since I've done personal injury law, but when you get in a car accident, the car insurance will come to you like real quick and get that thing taken care of so fast it makes your head spin, right? But if I had personal injuries as well, and I go into my settlement, I think I tack on my property damage with my personal injury damage plus any non-economic damages, and I come up with my settlement amount. Is that the way it works?
Yeah, with humans, yes.
Yeah, so the total thing. So in this case, we're just talking about property damage, and we're saying, but I'm still not allowed in the human case. I'm still not allowed to talk about my insurance coverage of that car, right? I'm not allowed to talk about that, but I am allowed in trial to include the car damage in settlement negotiations. I am allowed to include that car in my demand for damages.
Yes, your insurance carrier, you wouldn't, because you would have signed it over to your insurance carrier. They would make that claim.
See, that's where I'm getting at. So that's why I understand what you're saying, because what you're saying is if our car is damaged, totaled, in a lot of cases, I don't get that money twice. I get it either the one time to make my repairs, or I get it because I sue them because maybe I didn't have enough. I didn't have gap insurance or whatever that other stuff is. I think I understand it. I think I'm farther along than
Well,
I
it
was.
helps to have one person understand, well, two people understand it, if nothing else. Thank you.
Sadly, I think you need 12. And my inclination, with no offense, and no, I think that this has been this has been an interesting conversation. Delegate McComas, I'm gonna give you a chance to talk. My inclination right now is just to maybe hold on to this and talk a little bit more to the amendments drafter, just to make sure that we're doing it statutorily in the right way. I think I understand where we're going here, but I also sense some unease, and I want to make sure, given her experience, that we're dotting all the i's here. Delegate McComas, go ahead.
I guess what I would say is, I remember when we had all the pit bull issues and things like that, you know, and we had the family come in anyway. What I'm kind of concerned about is what is or what isn't insurance out there. I don't know if the dog would be included on your property insurance or not. I don't know if you can get, you know, insurance for if your dog is injured. You can get insurance for their health care. But I don't, you know, and it can cover certain things. But I think at this point, we might want to talk to a couple of, you know, call some insurance agents and say, hey, what happens? Because I don't know what insurance would be covered or not. And basically, we're talking about a hypothetical that there may be insurance and there may not be. And I think if it doesn't exist, then why are we putting this in the bill? So, and I don't know if you can insure if you have, you know, for animals on your property insurance.
All right.
So I think we need more information. I think we're operating in a vacuum of information.
The Delegate Davis has experience in the area, and I appreciate that, and I don't want to knock that down at all. But however, I think I'd like, we can pause. We've already paused it once. We can pause it one more time, and I can talk to Delegate Davis, talk to others, and we can maybe try and answer some of these questions. And we will do that. And so again, I appreciate Delegate Davis bringing the amendment. But right now, I think we'll just hang on to this one a little bit and make sure that we're getting this right. Not that we don't get everything right. I'm just saying, we'll just make sure we're getting this right. All right. That's it for now. Tomorrow we have brief bill hearings. We have bill hearings that will start right after the end of the legislative session or the session for the day. I expect that session will probably go again until 12 or 1, maybe a little later tomorrow. So I would expect to be back in bill hearings about an hour and a half after that. Then we will do another, there are 3 bills tomorrow. They have 3 witnesses. So now that we've completely jinxed that, let's see how long that bill hearing will take. Then we will, after that, we'll give it a half hour, and then we will go into another voting session tomorrow afternoon. With that, thank you all very much. This is